Okay, welcome everyone, and I'd like to reconvene this 32nd meeting of the Committee on Land and Physical Infrastructure. Welcome to everyone present and our viewing and listening public. This meeting is being broadcast live on Parliament's Channel 11, Radio 105.5 FM, and the Parliament's YouTube channel, ParlView. First of all, let me introduce myself. My name is Deerup Timal, and I'm the chair of this committee. And I'd like to invite committee members to introduce themselves.
Lisa Morris Julian, Vice Chair.
Simon de Nobrega, member.
Dr. Abraham, member.
Renuka Sagram Singh Suklal, member.
Okay, the purpose of our meeting here today is to commence the committee's third public hearing pursuant to its inquiry into the 2023 NIDCO report on the Sir Solomon Hochoy Highway extension to Point Fortin from 2010 to 2023. And with officials from Ministry of Works and Transport and the National Infrastructure Development Company Limited, NIDCO. Just to remind everyone that of the main objectives of our inquiry: one, to examine the efficacy of the procurement policies and procedures used to implement the project. Second, to determine whether due diligence governed the execution of all aspects of the project. Third, to assess the challenges faced in relation to the oversight mechanisms for the financial arrangements used to fund the project. Four, to assess the measures taken to ensure value for money in the contract with the OS. And five, to examine the reasons for making amendments, addendum, to the original contract with OAS. So I'd like to invite, introductions and opening remarks from the entities that are with us. So first I would ask the chief official from the Ministry of Works and Transport for opening remarks, and then her team can introduce themselves.
Good afternoon, Chair and members and the viewing public. My name is Sonia Francis Yearwood, Permanent Secretary, Ministry of Works and Transport. I am here with the team from Ministry of Works and Transport to provide responses to any questions or any requests for further clarifications as may be required on this particular project. We want to thank the committee and you, Chairman, and the members for taking the time to undertake this inquiry. Thank you.
Yeah, thank you very much. Would the members of your team please introduce themselves?
Good afternoon, Chairman and members. I am Anil Mohan Singh, Acting Director of Highways.
Good afternoon, Chairman and members. I am Petal Alexander, Director, Legal Services.
Good afternoon, Chair and members. I am Navin Ramsingh, Road Sector Specialist, Ministry of Works.
Okay, thank you very much. We now go to NIDCO, and Chief Official of NIDCO here today.
Good afternoon, Chair, members, and the public. Once again, we are happy to appear before your committee, especially because we sense that we are nearing the end. So as we appear before you today, we want to give the continued assurance that we'll try or done this to be accurate, to be precise in the perusal of the records, and to restrict our opinion, although in some cases, it's hard not to opine on some of the things that were done later on. But we will try to restrict our opinions as far as possible and just deal with the facts. So we're happy to be here, and even though we sense we are coming to the end of this session, we want to give our commitment to stand ready to provide you, your committee, with whatever additional information you may require from us. So we thank you.
Thank you very much, Mr. George. And would the members of your team please introduce themselves?
Good afternoon, Chair, members, viewing public. I am Esther Farmer, President, NIDCO.
Good afternoon, Chair and members. My name is Dennis Harritran. I'm the manager of the Engineering and Program Management Department at NIDCO.
Good afternoon, Chair and members. I'm Ravi Sriram, Manager of Finance, Corporate Planning and Risk, NIDCO.
Okay, so thank you very much, members of NIDCO. And Mr. George, the committee, we would like to share your optimism regarding this inquiry coming to an end. I think you used the word soon, but we may have some different views on that. I think some members may want to use the term the journey now start. But we'll see how much can be accomplished today. Coming out of the findings thus far, we think that it will extend into the next session of Parliament. And we'll see how it goes, all right? So just to start off, this being a sort of session where, I mean, thus far we have been engaging officials from the Ministry of Works and Transport and NIDCO, the current office holders. Before we get into engaging other stakeholders, former office holders, persons with responsibilities under the contract in terms of the engineer on record, several other parties. There are certain things that we would want to bring to your attention, to discuss with you today in terms of sort of closing off, in terms of the inputs from the current office holders, which does not mean that you would not be coming back at some point in time, should the need arise. And I'm sure we definitely will be getting that cooperation from you, should the need arise. But we wanted to get today to start off our discussions in terms of, we had looked at extensively conditions for the Addendum 1, which came out of the contract, the conditions, the basis for it, who were the authorizing officers with regards to the issuing of the addendum, the performance to some extent of the contractor following Addendum 1. I think we did get into that to some extent. But today we wanted to focus primarily on Addendum number 2. And again, the same approach, the rationale for the Addendum number 2, the conditions that would have brought it about, who were the major decision makers in the process, the crafting of the addendum, who played roles in the crafting of the particular addendum, and how effective that particular addendum was in trying to resolve the issues surrounding the project at the time, the addendum was being looked at. So I'll start off, and then other members would come in. But I just want to start off in terms of the clause 15.2e that deals specifically with termination of contract. And maybe, Mr. George, for the benefit of the listening public, if you can just brief us as to the intent of that particular clause, 15.2e, or in general the clauses regarding termination of contract under the conditions of contract for this particular project.
Yes, Mr. Chairman. Clause 15.2e deals with termination of the contract by the employer. And basically what it catered for, it allowed the employer to terminate the contract in the event the contractor became, and I will quote, bankrupt or insolvent, goes into liquidation, has a receiving or administration order made against him, compounds with his creditors, or carries on business under a receiver, trustee, or manager for the benefit of his creditors, or if any act is done or even occurs which under applicable laws has a similar effect to any of these acts or events. So that broadly is what it said. We had something like that happening on the job. It happened on the job. And I just want to point out, because we have been asked repeatedly, was the clause removed? The clause was not removed from the contract. It remained in the contract for the simple reason that the events that we just listed, they are not on a continuum of progressive failures. So it's not that if you're insolvent, you'll become bankrupt, so that once you started by being insolvent, you have covered everything here. So the clause could not have been removed because we saw it as independent events that can befall the contractor at any time. So even though we refuse, or when I say we, well, let's say we for the time, but NIDCO refused to take action under clause 15.2e because at the time the contractor was insolvent. They could not have removed that clause because that clause could have been used subsequently if that contractor were to become bankrupt. All right? So the clause was not removed, but they refrained from taking action under 15.2e, given that the contractor was insolvent.
Before we go further with it, we just need a matter clarified, because in Appendix 8 of your submissions, right? The Appendix 8 is headed Conditions of Contract, OAS. But I think in looking through that contract, what was actually submitted to us under Appendix 8, that clause don't seem to be there. I don't know if Mr. Haricharan could pull it up, but there seems to be a gap between 15.2 and then it jumps to 15.5 or something like that. That was brought to my attention. That's in the original conditions of contract. That is what you submitted to us. Yeah, please.
Mr. Chairman, may I attempt to answer this? I don't know whether you're looking at the particular conditions.
Oh, okay.
So 15.2, that clause was adjusted, but 15.2e suffered no such fate. Right? It remained intact. So I'm looking at the particular conditions now, and 15.2 termination by employer. So after subclause F, we are asked to include subclauses G and H. So that was the extent of the adjustments that were made, but 15.2e was very much complete.
Well, I think it caused some concerns when going through the documents, because the way the appendix is labeled, it says Appendix 8. What's the label? Conditions of contract, OAS.
Okay.
So maybe we should have had it as particular conditions of contract, just to.
We apologize for
just to avoid any
for the confusion caused, and we shall look at it and make the corrections and issue it to the committee subsequently.
All right, so we wanted to, I'll ask Member Sagram Singh Suklal to come in here in terms of, before we move on, in just establishing some timelines regarding, the Addendum 2. All right, so I'll pass over to Member Sagram Singh Suklal.
Thank you. Thank you very much, Chair. And again, welcome to all members. So Chair would have basically started the conversation with directly taking us to 15.2e. And I just want to reiterate the confusion that I myself would have had in going through the documents that were submitted. You would appreciate, or you could agree or disagree with me, but you would agree with me that the documents that were submitted at Appendix 8 of your original submissions, that would have been what records you all would have had, NIDCO would have had, pursuant to the original terms of the contract and all of that, right? In that Appendix 8, there is those contracts are signed by the parties to the contract, and in my review of that original contract, there is no 15.2e. So I'm not sure if it was just a bundling error, or I'm not sure. To my mind, I thought that was perhaps the contract, that because at the end of those contracts are the signatures of the parties to the contract. And that still remains. So I hear what you say. Your submission is that 15.2e did not suffer a fate of being removed from the original contract, but at least the submissions that are before us, for the record, the one that we would have reviewed, there is no 15.2e at Appendix 8 of your original submission. So I just wanted to make that point. So in my mind, I was wondering if that was indeed the contract. Now, when the report was laid, in the Parliament, 15.2e was mentioned, but in the actual evidence that is before the committee, there is no 15.2e. So, but you would have clarified that point for Chairman, and of course we would wait to see, at least if you could provide to the committee the executed original contract, where for the satisfaction of my mind, I can actually see a 15.2e in the contract itself. So that is just the simple point I want to start off by making, right? On the point of 15.2e, because we have started the discussion on 15.2e, what I would, and this question is open to any member, and any member of your team, distinguished Chairman, would there have been any legal repercussions had 15.2e been invoked for the benefit of the listening public? Would there have been any legal repercussions? Because your position remains, it had not been removed. The clause simply was not enforced. What would have been, had it been enforced, what would have been invoked? What would have been the legal repercussions?
Mr. Chairman, 15.2e is the easiest clause to invoke when it comes to terminating the contractor. Once one is satisfied that the events listed there, whatever subset of events listed there, once those apply or they have occurred, you terminate, and there is no recourse that a contractor could have then. So it was the easiest clause to enforce. Why it wasn't, well, of course, that is still very mysterious, but it wasn't enforced. And what is surprising is that, okay, so it gives you a list of events. So what one had to do, and in fact we did it, when I say we, NIDCO did it, was to find out to what extent what happened to OS in Brazil, to what extent what happened there matches any of the events here. And once it was established that it matched, you just had to follow the clause. So for example, we were well advised that the contractor was insolvent. we were well advised that because he had filed for judicial review, he was, well, you have to seek the approval of your creditors. And once your creditors agree with your, because what you're doing, you're remaining as an ongoing enterprise, except that you cannot pay your debts. So what you do, you meet with your contractors and seek from them an extension in the terms of, a new debt repayment plan. And to the extent that your contractors agree, not contractors, your creditors agree, you will now submit that to the court. The court will ratify it and will grant the company the judicial review. And once that judicial review is granted, a judicial administrator is employed to sit in that company, and that constitutes, what is it? You now have, all right. So one, you are insolvent. Two, you have compounded with your creditors. So that's 2 strikes. And well, let's take the third one. You have now carries on business under a receiver, or that trustee, or that administrator. So those 3 things were satisfied. So all you had to do was just terminate.
So, Chair, through you, and for the benefit, of course, for the record, so we are looking, so you would have gone through the application made by OAS for the judicial reorganization of its organization, correct? For the benefit of the record, can you identify the date or place on your record the date in which your records would reflect that OAS would have filed for judicial reorganization in Brazil?
All right. Mr. Chairman, on March 31, 2015, OAS filed for judicial review.
Right.
I would not have, when I say I, we would not have seen that filing because it's usually between OAS, his creditors, and of course, the judge in Brazil.
For the benefit of the record, could you then identify what was the date in which Addendum 2 was executed? So on the 31st of March 2015, we had OAS making an application for judicial reorganization. For the benefit of the record, what date was Addendum 2 executed?
Mr. Chairman, Addendum 2 was executed on September 4, 2015.
Now, did NIDCO, so Chair, can I continue through you? Okay, so thanks for highlighting those 2 dates. For the benefit of the record, again, did NIDCO, so we have well in advance, so we're looking at in about, March, April, May, June, July, August, September, 6 months after an application that was made in Brazil for the reorganization of OAS. 6 months after, we have NIDCO executing this addendum. You would have already identified, Chairman, what were some of the red flags that were no doubt before NIDCO as it relates to OAS operations and standing at that time. Did NIDCO then source any independent legal advice? Does your record reflect, is there any record that reflects that NIDCO sought legal advice prior to entering into Addendum 2, almost 6 months after they already had before them information relative to OAS standing?
Mr. Chairman, NIDCO used the company, legal company that is, CMS Cameron McKenna LLP out of London. That was the main legal body. Cameron directed or advised NIDCO to retain the services of a Brazilian company, Kroll. Yes, Kroll. So Kroll, sorry.
Sorry, go ahead.
Right. So Kroll was a Brazilian company on the ground, looking at the goings on, looking at the developments, and he will submit reports, weekly sometimes, from time to time, to Makina, and then Makina will pass it on to us. So those reports were.
So for the record, they
available.
did, so very plainly, they did get legal advice prior to entering into Addendum 2, and by the firm that you would have identified, correct? Do you have a copy, sir, of that legal opinion that was received by NIDCO advising that they can proceed with this addendum, the execution of this addendum?
Yeah, Mr. George, before you answer, I just want to interject a little bit for probably a bit more clarity so that that the issues are very clear, right? In terms of when the member asks a question of seeking legal advice, in the context of that, it's two things. One is that it was legal advice sought as to regarding the termination of the contract, that's one, or was the decision to terminate made by NIDCO, and probably other stakeholders will get it. And subsequent to that decision being made, then the legal persons were asked to get involved in terms of crafting of the addenda.
Okay, Mr. Chairman, let me see if I can separate this thing.
Yeah.
Termination came much longer, and it came under my watch.
Mm-hmm.
So of course we got legal advice to do that. So we're looking at the stage before. When the 15.2E was not applied, they got legal, and the legal advice that they were getting then is not so much, should we terminate?
Exactly.
It is, what is happening, right? So it was like an investigative kind of a thing. So they'll investigate, say what is happening, and that information will come to us. So if, all right, for example, during the period, OAS's credit rating went to D. Standard & Poor's reduced their credit rating to D. And that is, well, I should tell you about OAS. All right. We had Contractor OAS SA. That was the constructing arm of the conglomerate OAS SA. And there were several different companies in that group. So we got from that legal entity as well that in February, OAS had, that is the OAS SA, they had failed to meet a debenture payment for the ninth debenture issuance. They had failed to meet the interest payment that fell due in January. So you failed to meet that. Your credit rating just went way down, and the banks had just stopped your credit. So we got all that information coming through to us. So while we are getting that from our legal people, OAS, of course, Contractor SA, they're writing us and giving us assurances. Yes, this thing is happening, but you know, we are not, it's not going to affect you. And so much so, look, we have extended, we have renewed the securities and bonds that we have. And you will know that in the recitals, we repeated that. Not realizing that OAS had to renew it. If they did not renew it, all those securities, and we're talking about standby letter of credit, could have been called or would have been called. So it was in their interest to renew it. But it was put forward as though, well, your work here is not going to be affected. We're going to be doing your work. So the question is, who did you believe? Who did we believe?
Okay, so just for clarity, what you're saying is that OAS had no choice but to renew the standby letter of credit for the retention, for the performance bond, and also for the advance payment. They had no choice. Otherwise, they would have been in a position where it would have been forfeited.
That's correct. If it is allowed to lapse, so you have not renewed it, we, how your lawyers say, obligee, could have called it in.
Okay.
Yeah.
Yeah. Members of Council. Dr. Singh, please continue.
Thank you, Chair. Okay, so now you say that there were correspondences between OAS where OAS was constantly giving the reassurance that notwithstanding our financial standing, things, they were giving the assurances that it could still execute and complete the contract. Those correspondences, you have copies. Was it sent via written letters to NIDCO? How was those assurances were given via what means?
Mr. Chairman, those correspondence, they were not verbal. We have copies, and we'll make those copies available to the committee. So we'll take a note, and that will be one other thing that we'll make available to the committee. Yes, we have those.
P.S. If I'm... Sorry.
One of your responses to one of the questions, you did say that you did get email from OAS on November 17, 2014, in which they confirmed the contents of the report in the engineering news report that indicated that OAS officials were arrested and were being investigated for charges related to corruption. Then I think you mentioned an email of February 4th, 2015 regarding details of OAS financial status. You also refer to an email of March 10th, 2015 from Ivandro Daltro, giving notification of impending filing for Chapter 11 in the Brazilian court. So I think in addition to these, if you have any, based on the question from the member, if you have any other additional information, the committee would be glad to receive those.
We shall oblige, Mr. Chairman.
And then on the letter dated March 31st from the same gentleman, Ivandro Daltro, official notification that the OAS parent company had filed for judicial reorganization in the Brazilian court. Now, I think you have provided some of it in Appendix 29, but I'll just ask if you can recheck and see what Appendix 29 had, and if there's any additional based on what is being asked by the member, if you can please submit. Yes, member.
Thank you, Chair. Chair, through you, to the Permanent Secretary, I'm just interested in standards and procedures now. Ma'am, can you describe, for the benefit of course, the committee and the listening public, can you describe the standard procedures applied for amending a contract such as the one that existed between NIDCO and OAS? To your mind, what is the standard process and procedure? So Chairman Herbert would have gone through the negotiation process that would have taken place, the correspondences, the assurances given by NIDCO and by OAS, the legal advice that they would have gotten from this UK firm And of course, a decision, ultimately, we all understand the record taken to still allow OAS to proceed with the execution of this addendum too. But standard processes, procedures, contracts of this nature, where we are looking at in excess of $900 million in bonds and a significant loss that eventually occurred to the tax-paying citizens of this country. What is the standard process and procedure for amending contracts of this nature?
Whilst you're outlining as well, if possible, where you could also probably tie it into the actual conditions of contract for this particular project, as much as you can.
Okay, thank you, Member. Thank you, Chair. So I want to put it into two parcels almost. One, the Chairman would have outlined the process because fundamentally the contract is between NIDCO and the contractor.
Understand.
So that at the end of the day, that is where the change would lie. It would lie within NIDCO, it would lie within NIDCO's legal department, etc. However, the member made a very valid point. The changes that we are speaking to now would have material impact on the contract and the costs possibly, and invariably, present-day NIDCO would, and I'm saying present-day NIDCO simply because I'm dealing with present-day NIDCO, present-day NIDCO would advise the client, who would be the Ministry of Works and Transport, of what is being undertaken and the intended course of action and what that course of action, the impact that may have, either on scope, cost, time, quality, etc. And the ministry would be advised, and there would be a process whereby the ministry would indicate their non-objection. In a huge project of this type, invariably, if it is that there is some large change to be made in any of those areas I just mentioned, it would, of course, the minister and then possibly cabinet for that type of change.
Yeah, volume two of 2, in response to objective 5, question 8. So we're on page of 6 of 24. You know, the question was asked regarding respective roles played by Ministry of Works and, well, Infrastructure at that time, NIDCO, the consultant, and the state, leading up to the establishment of Contract Addendum number 2. So in the response from NIDCO, indications are by way of letter June 30th, 2015. And it is included in Appendix 33 that it is said here that NIDCO informed the Permanent Secretary of the Ministry of Works and Infrastructure as follows. OS was experiencing financial crisis and had filed for judicial review. NIDCO recognized that the contractor was experiencing financial and resource difficulties, which were impacting on the project. And NIDCO had devised strategies to ensure continuity of the project and connectivity throughout the project by introducing suitable local experienced highway building contractors to be employed as nominated subcontractors. Was there a formal response from the Ministry of Works and Infrastructure at that time to this letter from NIDCO?
Mr. Chairman, our record does not reflect that. but permit me to just give a little bit more information on this. In the next paragraph, I think it talks about the matter going before the board. Yeah. On August 20, the board approved. Now, one might argue, well, the board is a legal body, but I always argue that all things are profitable, legal, but not all things are profitable. So, if I have to do the same thing today, the first thing I will do, as happened when we were terminating, a very detailed report went to the line minister, and then he will say yea or nay as the case might be before we move further on it. But there is something else that is happening here. The government of the day formed what you call an oversight committee. And that oversight committee had 6 ministers and 3 or 4 senators in that committee. And one of the objectives of that committee was to undertake proper monitoring and evaluation, to ensure that proper monitoring and evaluation is undertaken and that the country receives value for money output. And that committee was formed. The notice of that came in Cabinet Note WT, note number, yes, WT 1150. And the Cabinet, and further, we were told in minute number 67, that's the board minute, the deputy director of the board expressed concern about the goings-on the project. The president then gave a very detailed analysis of what was happening. At the end of the analysis, the deputy chairman expressed the view, and I will quote, that although the situation regarding the project was complex and challenging, NIDCO was approaching the issue in a rational and professional manner. The chairman of the board then asked whether the Minister of Works and Infrastructure was being briefed on these matters as they progressed. The president responded as follows, and I quote, "The president informed the board that the Minister of Works and Infrastructure is briefed on a weekly basis during the ministerial meetings convened each Friday." So what is this telling us? The ministerial body that was formed to ensure that we get value for money, they were meeting every Friday, and they were being apprised as to what was going on. And indeed, you saw signs of that a lot when it came to land acquisition and compensating people for land acquired. So, I'm saying all of this to mention that the steps that were being contemplated under Addendum 2 should have been, ought to have been discussed with them at that meeting, at that weekly meeting that they had, before it went to the board. And in fact, we have the actual report from the board asking the question, and they're being told that yes, it is done, and it is done at that weekly meeting.
Okay, what I would ask coming out of that is if, Ms. Yearwood, if you are aware of any, have you come across any records of those ministerial committee meetings, or are there any minutes of those meetings, or any notes arising out of those ministerial review committee meetings?
No, Chair, I can't say that we have come across any of notes or minutes of those meetings. We can undertake to look at, specifically, but.
All right. The chair of this committee was, if you would like to inform us, if you have that information.
And Chair, through you.
Mr. Chair, oh, sorry.
And Chair, through you, can NIDCO just identify the members, the ministerial members, please, based on, of course, minute number 67 and WT 1150.
Chair, I shall so do now. The chairman of that committee was Honorable Kamala Prasad Bisesa, the Prime Minister. The Honorable Stephen Kadis, Minister of Trade and Industry. Honorable Winston Dukaran, Minister of Finance. Honorable Dr. Rudal Munilal, Minister of Housing and the Environment. The Honorable Chandresh Sharma, Minister of Local Government. The Honorable Jack Warner, Minister of Works and Infrastructure. Senator the Honorable Emmanuel George, Minister of Public Utilities. Senator the Honorable Kevin Ramnarayan, Minister of Energy and Energy Affairs. Senator the Honorable Dr. Bohindrat Tiwari, Minister of Planning and Economy. And the Honorable Stacey Rupnarayan, Minister of State in the Ministry of Works and Infrastructure. That was the committee.
Okay, so what I would like is that any information in terms of the composition of the committees would please submit to the committee. If you can submit those to the committee. The list of names, yeah? You can submit.
Well, I'm not clear, Mr. Chairman. I mean, in addition to what I've just read out and the reference I've given,
and
I
other,
must give you. Okay.
If you have whatever other names, yeah.
No, those are the people.
Mm-hmm.
Whoever attended the meeting were just attendees, but those were the people constituting the Oversight Committee.
Chair, through you, just to be clear, Mr. George, because that's how I interpreted it. This information that you're placing on the record was taken from minute number 67, and it was taken from the note and the cabinet note 1150. This is where this information comes from, correct?
You're absolutely correct, member.
Right. So there is a record, Chair.
And I think just for clarity, along the lines of what I was asking is that there would have been different administrations, right, through the life of the project. And so whatever committees that there were, not just the only, not just this committee, but there were other oversight committees outside of NIDCO that you're aware of, that if you could submit that information to this particular committee.
And Chair, through you, if we can also have a sense as to when this committee was constituted. I guess the information, the note would also elucidate that point as to the actual time of the birth of that committee. I'd appreciate, if you have the information now, feel free to share.
I don't have any other information as to the time that this group was put together. What I do have, and I will make available, we have some minutes of those meetings, yes. However, we do not have the minutes leading up to or around the period of that Addendum 2. But we have some earlier minutes dealing with the land acquisition issue.
Okay, but in terms of the with the change in administration, were there any other new oversight committees that were set up with regards to that NIDCO had to liaise with?
I don't recall being subject to, working with another oversight committee. What I do recall is that you worked with the line ministry, and you took your cue from them. So that when, for example, we terminated, and we were faced with a huge bill from workers who were terminated and they were not paid severance and other payments that were due to them. I think it was $8 or $9 million US. They were terminated. So what did we do? We made representation to the line ministry saying, listen, we'll have to approve some sort of a payment to them I know there is no, we know that there is no privity of contract between OAS and them. So we didn't have any privity of contract with them. But if we didn't do that, as we risk assess the thing, if we didn't do that, we will not be able to continue the works. And, well, the government saw the virtue of that and authorized us to negotiate with the company, the labor union, representing those workers at the time. And at the end of the process, the labor union accepted being paid, it was 33 cents on the dollar owed to those persons. And we shook hands, the payment was, we went back to the line minister, and they approved it. We were able to just move forward. And that's why the continuation of the works happened without any disruptive, how should I say, any disruption as existed prior to our taking over.
Okay, so before I ask Member Sagram Singh Suklal to continue, we can conclude safely that you all have not come across any correspondence or any documentation regarding any matters being discussed or taken up between NIDCO at that time and the Ministerial Oversight Committee.
That's correct, Mr. Chairman, without a doubt.
Yeah, okay.
Thank you, Chair. P.S., I want to come back to you, please. Now, and this, of course, is to the benefit of, the regular man on the street or taxpayers. Now, legally, and, that point was also made by the distinguished chairman, we understand that NIDCO is a company operating on its own. We understand contractually the relation or the role that the ministry would play. Of course, as a line ministry, you are basically the authority that is vested with the responsibility to oversee the runnings of these state-run companies and entities. But these entities are given their flexibility, they have their mandates, they can enter into their contracts, all of that. You have made that point as it relates to Addendum 2. You have made the point that NIDCO, of course, would have had the latitude to engage and have conversations with the contractors, and that's the normal running of things. We understand that. We understand that NIDCO is a state entity, and because of that, monies that are allocated to NIDCO for any project comes from the Ministry of Works and Transportation, correct?
Once it is a Ministry of Works and Transport project, yes.
Once it's a Ministry of Works and Transport project. In this instance, allocations that were given to NIDCO for this particular contract, that would have been allocations from the Ministry of Works and Transport?
Not at all times. From when the project started, if my memory serves me right, it would have been transfers based on treasury deposits to NIDCO. I believe it is only in the latter part of the contract that it started to come straight from Ministry of Finance via the Ministry of Works and Transport. That would be down in 2014, 2015.
In your experience, once a ministerial committee now is created, probably Mr. George, you can chime in here as well. Is there any record to reflect then what would have been the guiding policy for this ministerial oversight committee that was created? What were their rules? What were their responsibilities as it relates to the execution of this contract, the completion, execution of this contract?
Well, we as NIDCO would not inquire into that. If a minister calls you, your line minister calls you, and he advises that Cabinet has approved the formation of the ministerial committee, whoever it is, to exercise oversight over this project, you will be fast and loose to think that, well, you ought not to be guided by that. And that's all we need. And we'll just be guided. So then they will tell you, well, okay, when we meet in, what are the terms and what have you? And then we'll be guided by that. So I imagine that that should be the same thing throughout. But if you feel that you have the legal authority to act because you are independent and you have laws, you know, and the board could do it, then you become a rogue. And you ought to be dealt with if that happens.
So, yeah. So before we continue with that line, I'll just, if we could just pull back a bit to the Addendum 2 and the factors leading up to the Addendum 2 itself, right? Now, in the actual Addendum itself, Mr. George, the actual phrasing of the Addendum, right, itself, it says on the first page, really, whereas, of course, it states it's between NIDCO and Contractor OS, and whereas it says the contractor has filed a judicial reorganization process in São Paulo, Brazil on 31st of March 2015. Okay, that's very clear. Now, B, it says wishes to remain operational on this project, provided that some scope and commercial adjustments are implemented. Okay. But C states, despite the judicial reorganization process, has been able to maintain its contractual obligations, renew bonds and guarantees, and remain operational on the project. Now, in light of that, that is actually stated here in the addendum to which the parties signed to. But in light of that statement and the documentation that you have submitted to this committee of the engineering record, that's AECOM, there's a slew of correspondence and reports that has been presented to this committee in which AECOM has clearly outlined dissatisfaction with the performance of the contractor repeatedly on significant occasions. And I'm just trying to understand that statement here in the addendum in the context of what the engineer on record had to say.
Mr. Chairman, in my mind, there continues to be a disconnect between the recital here and what was happening on the ground. So, and if I might just talk about two of them. Even this one where we talk about, it says that, let's say D. Okay, it says, despite the judicial reorganization process, has been able to maintain its contractual obligation. No, that's not true. All that you know, yes, they have renewed the bonds, and as I said earlier, they had to. If they didn't, if the thing's coming to, likely to expire, and you didn't renew it, it'll be called in. So you had to do it. That does not constitute any desire or any ability or will to continue the work, because while you're saying that here, they had virtually slowed down operations on the site. So where you are getting the evidential proof from that that was the case. And then here's the one that bothers me no end. You do not wish to remain mobilized after the current contractual completion date of the works. No.
I was coming to that.
You have to remain mobilized until you finish my job. You can't tell me you do not wish, and we are doing, all of us, NIDCO, Oversight Committee, everybody, we are facilitating that. You do not wish to mobilize, and then we're saying, well, okay, so we can terminate, and you could go. So that recital here it might, you know, it sounds, well, it makes no sense to me. I have a problem with it. And I don't understand how we could allow that large company with all the abilities, international company, to come here and allow that to sort of take place. I have a problem with the recital.
Okay. All right. Then the recitals regarding the employer, which is on page 2 of the addendum. So the first recital says, wishes to minimize potential risk to the works due to the contractor's judicial reorganization process in Brazil. So what it does, it begs the question that whether this arrangement, this addendum 2 arrangement, was really in terms of minimizing potential risk to the works. Was that really a realistic, is the recital really realistic?
Mr. Chairman, it's not. They're using this buzzword risk and feel, well, that will say everything. The risk to the works, well, all right. Let's say that you feel that there's a genuine risk to the works. What was your model? You got together what you call nominated subcontractors. Well, that has another thing. Well, I won't go there, but if I'm asked, I will certainly explain it. Nominated subcontractors, and you're going to allow OAS, the stricken OAS, to enter into contracts with them. And then, when OAS, because you know he also said that he doesn't wish to remain after that date. So, in order for OAS to hightail it out of Trinidad and go home and rest his weary bones, OAS is now going to novate those contractors to us. And we will then manage the thing to completion. Where did we get well, it's not parliamentary to say dotish, but where did we get that thinking from? Why, for example, if you say that OAS has a sort of reduced ability to do the work, why didn't we authorize the use of subcontractors? Because see, OAS couldn't just bring on subcontractors. It is not, under the contract, they can't do that. Those subcontractors must be authorized. So let us say, well, the personnel and thing gone back to Brazil and they can't do the work and thing. You authorize them to use subcontractors. They manage the subcontractors' works. OAS is still liable to us, liable to the employer, and the work is done using that approach. But no, you didn't do that. You said, okay, you bring it, and clause 13.1, that talks about right to, what is it again? Right to vary? Yes. 13.1 speaks to that. And you know what 13.1 said? There was, under the particular condition, they asked to put in a paragraph where, well, 13.1 in its natural thing does not allow you to vary the contract to any large extent, right? You're very circumscribed as to how much you vary it. The particular condition said, okay, you can vary it now up to 10% of the value, and more than that, where you are doing it to bring in contractors so as to deal with a default of the contractor, that does not apply. So the same work that was excised from OAS, you could have done it contractually, take it out from them. And you, when I say you, I mean, you could have then set about employing the contractors and getting the work done. That is what we did for the part that we opened recently, you know, but that wasn't done. So I mean, the thing is so wrong on so many different fronts.
All right, but to try to try to bring it within a more definitive context. Are you aware, or Ms. Yearwood, of any risk analysis, proper risk analysis, or detailed risk analysis exercise being conducted? And if so, have you come across any risk assessment report prior to the getting into Addendum 2?
Chair, I will ask the chairman to respond to that.
No, are you aware of any risk analysis exercise, whether it was outsourced or internal? Yeah.
I'm going to address that now, Mr. Chairman. So, in 2013, NIDCO got a company called Marsh USA Inc. to provide risk assessment services. And Marsh,
Could you just repeat the date? Sorry for interrupting you. March 2013, you said?
No, in 2013. I did not have the month and so, but in
okay.
2013, the name of the company is Marsh, M-A-R-S-H, USA Inc. And they came in and they did a risk assessment, very detailed risk assessment of 2 jobs, one of which was Saltmount Hochoy extension. And they identified basically 3 key risks areas and of course mitigation measures. And here are the 3 risk areas. Land acquisition and the primary driver there was cost overrun, and it would have contributed significantly to project delay. So they identified that, and they asked for certain mitigating measures to be taken. The next one was OAS construction delays. And what did it say? Lack of expertise, delays due to lack of material. So they flagged that. Those are triggers that will cause you not to realize your end date, or it will cause overruns. And then the other one was social unrest. So those were the 3 key risk factors. There are others, but those were the ones highlighted. So, in answer to your inquiry, Mr. Chairman, yes, what do you call it? NIDCO, they are mindful of risk and the effect that risk can have on realizing an outcome, a desired outcome, and they did take steps to sort of look at that, albeit a bit late, because you're talking about 2013. But in any case, it was before.
Let me ask you a difficult question, and also maybe Ms. Yearwood, if you could come in if it's possible, but particularly in the context of Addendum number 2, what measures within Addendum number 2 were taken to mitigate against those risks that were identified?
I'm tempted to say, Mr. Chairman, that they excised that portion from, is it penal? Penal to Mondesir, because that section did not have, all this, the acquisition was still, in some cases, in progress. So I will credit them and say, well, okay, you excise it. But when you really check why they excise it, that's not what they're telling you. They're telling you, in order to bring the scope now within the limited ability of the contractor, it's better to take that out and we will do it ourselves. So, but it can be used, it can be referenced as something that was done in response to that, although it is not totally clear that that was what happened.
Because the reason I'm asking is that for every question that we ask and response, I'm trying to give a balance as well, in terms of, so if the risk assessment did identify, it's only natural that I would ask, well, if, attempts were made to mitigate the risk, And I'm glad that you have identified that as a possible attempt at mitigation. I just want to go down with the recitals, in terms of the employer. We'll come back to B, which deals with the nominated subcontractor, because I think you intimated that you would have some things to say on that if you are asked. But if I go to recital D, it states that recognizes, whereas this addendum recognizes the contractor's contribution and capability to developing portions of the project via their resources and management, and hence would prefer to negotiate an arrangement regarding the contract scope and some commercial matters whereby the contractor remains on the project commensurate with his financial and management capacity and level of resources. Now, I'm just asking the question because in the context of what is coming out in the discussions, at least from what you are saying, Mr. George, such a recital to me was not consistent with what was actually occurring based on reports from the engineering record, particularly from the engineering record as to the performance of the contractor.
I concur, Mr. Chairman, and they had absolutely no way of validating that recital here, but it sounded good, so it was used.
What do you think was intended by recognizing the contractor's contribution? I'm thinking about it in terms of contractual language and contracts. What contribution? Why put in that word there, contribution? It's okay. I'll take the response in the context of what you have expressed before. And then to come back to the question of the nominated subcontractors, because what has been said in the responses here is that apparently the engineer, AECOM, did actually were part of that recommendation or made that recommendation. What is being suggested in terms of the responses?
Mr. Chairman, let me just attempt to outline what the plan was. NIDCO contacted or communicated with the Ministry of Works to find out, well, first of all, the part of the section of work that they excised from OAS was compartmentalized into 7 packages. NIDCO then asked Ministry of Works, Ministry, tell me, give me some contractors, good contractors who are into roadworks. And well, Ministry said, okay, we have used A, B, C, D. NIDCO took those 7 contractors and carved out packages, 7 packages now, and gave it to the contractor. Gave it, so from A to B, this year, contractor A, you focus on that. Contractor B, you focus on that. And they divide up that just like that. And then the contractor now, well, of course, he's given documents. The original document, contract, is yellow book, design and what have you. Now a contractor, you have to design. The contractor will bid and bill. So you have to give him information on which to work. So yes, they used AECOM to help to craft those packages. Packages were crafted and given to the contractors to price. The contractors' submissions were moderated by a group of, drawn from essentially NIDCO. So the contractor comes in with his price, and that group now looked at the price, made changes, talked to the contractor, and they arrived at a figure.
No, the group, you're using the term group, but was it NIDCO's tenders committee? The bids were invited through NIDCO, right? NIDCO invited the bids. And NIDCO received the bids. And the evaluation of those bids were done by?
Okay, let me slow down and be a little bit more precise. The tender committee is there, but that is an evaluation committee that will now look and make whatever changes, negotiate with the contractor. After they would have had a meeting of the minds as to what is a fair and reasonable price, that information now will go with a report to the tenders committee. The tender committee will look at it and then stovepipe it up to the board, and the board will approve. Right? So that's what they used. And the curious thing about that is, so that was happening in May and June 2015. The addendum was crafted towards the end of August, well, of course, it was signed in September, on September 4. So towards the end of August, on August 20, the addendum was crafted. And if you were to go now to Addendum 2, and you look at the prices that they have included there in Addendum 2 for works to be done, and I'm talking, well, I don't know where they have, but I will just go on. There is a section called, Section 2. Well, so I don't know, I wish we could have projected that. But anyhow, where they did a sort of a reworking of the price, the contract price for OS. At the start of that worksheet, they backed out $124.26 million from OAS's package to be applied to those things that they took out. When you go down now to, so that's right at the top. When you go down now to the bottom section, where Section 2, right at the bottom of that page, they have put in those packages, and they have placed their values for executing those packages. What they are now putting back to actually do the work is not 124 or more. They're putting back $117 million. Okay, you might say, well, all right, so they got hard nose and they were able to negotiate, and so not too fast. In June, when they met with the contractors and so on, they moderated price and they agreed price, if you were to add all those amounts, instead of 117, what they have in here, it came to $134.9 million.
Just for clarification, this is US dollars, right?
Oh, yes, US dollars.
Yeah.
Yeah, sorry. Yes.
So, Chairman, what we're seeing here is a reduction of scope of works, pulling it out, and an increase in the remainder of what they kept in the contract?
Sorry. Yeah, the contract figure went up for OAS because there were some other things that they added. In fact, they did it with the proviso that it would not increase the budget because they will get it from contingency and some other thing. You know, as though the budget was ours to spend all on OAS. Anyway, so that's what they told us. But what is more, what I find is objectionable. You remove the work. You're putting it back at a discounted rate, because you have to be able to say, you have to support a narrative. So if I can now put it back at that discounted rate, the total figure will appear to be, yes, it's going to be increasing, but not as much as it ought to have if you had used the proper rate. Because the proper rate, you established it earlier in June. So how come you have these rates here that are lower than what you established in June? So these are some of my concerns. I'm sorry to be regaling you with so much of my opinion, but, that's what I'm seeing from the information that I'm perusing.
Were any of these subcontracts, the nominated subcontracts, were any of these subcontracts awarded?
No, Chairman, none was awarded. Okay. And this was its own story because you see, even though they wrote that in Addendum 2, they did not act on it. Because what was happening, our favored contractor, OS, at that time, was in the market searching for loan. And they actually arranged a loan of $65 million in the difficult times that they were experiencing. And that loan was coming from a syndicate, from I think 3 syndicate banks. But those banks were already involved because they were the ones holding the standby letter of credit. So, and the thing about that $65 million, none of it was to be used in advancing the work. All of it was to pay down debts that they had. And when you look at their term sheets, the term sheet that they gave you for that, it was something. Well, I mean, I don't understand how they expected anybody to just accept it. Let me give you one example. They said, for example, that the performance bond that you're now holding is about $46 million US dollars we have in standby letter of credit. That performance bond, we're going to reduce it by, I think, down to $20 million. And why are you going to be reducing it? Because the contractors that you're bringing on, they will be taking out performance bonds, so you'll be protected there. But here's the catch. The bank wanted us, and what they said, the bank going to give you the money, their $65 million, pari passu. So, you have not employed anybody yet. You tell me you want to reduce the bonds that I have for you. So if I have $46 million for you, I must give you, I think, 20, and I must keep 20 and then give you the remainder. So I must go and break it. Well, let's say, modify it. So I keep 20, and the rest I return it to you. And I'm doing that pari passu with the bank because the bank must give me the $65 million. And although I'm doing that pari passu, I have not yet entered into any contract with the nominated contractors. That was the one-sidedness of this thing that one was seeing.
All right, but the addendum itself did not, there was no agreement to reduce the performance bond, was there? In the addendum itself that was signed.
No, the addendum did not say that. Mm-hmm. But that was all part of the wanting to go home because they don't wish to remain here. So let us see how we could just free ourselves and go home and leave the employer holding the bag. And we almost facilitated that.
Chairman, just to ask Mr. George, while, again, you're saying a lot of it is opinion, but I am of the opinion, if anyone should be an expert opinion on this matter, it should be you, right? Correct? You know, you understand, you were there, and you've been going at it for quite some time. But listening now, it seems as if almost from the beginning, this was a plan. And my concern as a member of this committee is that OAS conspired, and let us leave the person or persons unnamed for now, because I'm really hoping we can get them here, to defraud the country on a whole. And what is even more alarming to me is what was done to the local contractors, because I know this project was completed exactly the same way you said it should have been, right? It was broken up in several sections, etc. All right, I'm just asking, nothing too long, sir. don't want to put you under pressure. The difference with that then and what you did differently now regarding the highway, for the completion of the highway, it progressed quickly, and I'm lucky that I was here to see it myself. Go ahead, thank you.
Mr. Chairman, so what we did was as follows. We terminated OAS. We called in the standby letter of credit. And yes, OAS went to the Court of Arbitration, and the matter has been appealed and what have you. We called in the standby letter of credit. We realized a sum of $140 million US. We got the approval from the LCIA to, and in fact, OS was at one time, well, they went after us to have that money mothballed and held until this thing is finished. But we fought that, and we got the approval from the LCIA to apply the funds collected as a result of the calling in of the standby letter of credit, to apply it to the project, to advance the project, and for paying legal fees, because yes, there were legal fees to pay as a result of the standby, of the LCIA proceedings. So, and then, with that now, we are able to, so we cut this thing up into smaller packages, and we are able to go out to the local industry using competitive tendering. Every one of those 12 packages, everyone was competitively tendered. Nothing was just, you say, okay, you come and do that, you come and do that. And of course, the contractors came, and they did not disappoint. So we have what we have there today. All right, there are two sections. Well, let's say two. The creek, there was a failure on the creek. And it was not a contractor's failure. It was, at worst, a design assumption that just did not pan out. So that has to be repaired. And then there are two areas where we are straddling. We have to construct over existing pipelines, huge oil industry pipelines. And that is, but we have to first of all get an agreement from them that yes, we can do this thing over your pipeline. And having agreed, then we can go on with the construction. But that is taking a while.
So in your professional opinion, this could have been done all along, right? And I also just want to make it quite clear for our viewing and listening public. It was competitive tendering was the process versus hand-selected.
Yeah.
The special treatment that OAS, a foreign company, received at the hands of the then government to now all right. I just want that clear too, please. Thanks. Because I have a lot of persons only messaging me.
You are being asked to express an opinion?
Mr. Chairman, if I may, I want to just read into the record a letter, a very curious letter, email that we had from OAS. So OAS is writing two of our employees. So things have gone sour. When I say sour, I mean they're off the scene and so on. They're not there, they're not doing any work and thing, and we are working up to the eventual termination. Hear what OAS talk, normal salutation, and he says, and I quote, "I am happy to have an opportunity to try to help find a way to allow the project completion." He's telling two of our employees that. He said, "It is confirmed my arrival in Port of Spain on Sunday. I will be with name call, the CEO and CFO of OAS." So they're coming in, a team of them come in now. "We will stay up to Thursday, and if it is necessary, I am available to return on the other week." Well, English is not his first language, so maybe. "In my opinion," and this is what I can't come to terms with it at all. I continue. "In my opinion, OAS and NIDCO and NIDCO should put pressure on the government to find a way to fine-tune and allow the project progress without OAS. And then, well, yes,
what was the date of that letter?
Oh, that was written on March 20, 2016. It was an email, right? And then they were saying, well, I mean, there are other things, but he said, finally, I hope to get your support to find a way to send a right message to the members of the Infrastructure Committee, Prime Minister and Minister of Finance, and facilitate the dialogue with OAS to terminate the contract on amicable way. All of a sudden, this thing, you know, I don't know, I mean, this is no amity contest. It's not about to terminate in an amicable way. It is to be fair and reasonable. But this thing got into the lexicon and everybody talking about terminating amicably. And the only person laughing here is OAS. The Addendum is bad.
Yeah, sorry. I'll have to start over that. Coming back to the addendum itself, addendum 2, on page 4, under guarantees and insurance, section 4, it states that the outstanding letter of intent payment shall be repaid in full in the first interim payment certificate following signing of this contract addendum by the parties. I am just asking, was this done?
OAS waived its right to pursue any measure as a result of delayed payment. So they pushed, because I think that IPC was held due in October. They pushed it to January. So there were adjustments made. So whereas at the end of October he could have taken action, and I didn't take action. The government should have responded actually. But anyway, he could have taken action. He had a memorandum. They had a memorandum that of understanding executed between OAS and NIDCO, where they gave the assurance that they're waiving the rights now, waiving rights to move, what you can do when payments are delayed, you can reduce operations on site. If it continues to be, delayed for any period of time, you can withdraw from site. And of course, at the end of the day, when the payment is finally made, there'll be interest payments, and so that will have to be made to you. So there are remedies for the contractor. And of course, if it remains a long time, you could terminate.
Okay, could you recall the outstanding amount for that letter of intent repayment that was owed at that time? Because this is because deductions weren't being made in the earlier parts of the contract, right? So it became an issue.
At the time, there was IPC 50. The value of IPC 50 was we had paid was 20 or so million US dollars. A part payment was made of about 8, and then there was a 12 remaining. And while that is happening, you had IPC 51, 52, 53, and continuing.
Yeah.
And then we issued, was it IPC 56? Well, no, they're not paying it at all. All right, so, I wonder if Ravi could help us here. You could rattle out those things for us? Yes?
Have
All
those
right.
offhand.
All right, okay.
Oh, no, well, you could always provide it to us
Well, yes,
in,
Mr.
in,
Chairman.
in our written response.
Yes, we
so
shall.
We have the exact
We shall so do.
figures,
We'll
yeah.
give you the listing of all the IPCs that were outstanding and when they were paid.
Yeah.
And of course, the memorandum of understanding that was effected between OAS and NIDCO.
All right, so I'll just like to come to the date for completion in the same addendum 2.7. The contractual date for completion for remaining works undertaken directly by the contractor, except the work by the nominated subcontractors, shall remain as defined in variation number 18. So could you please provide us with a copy of that variation number 18? Such date, 28th of May, 2016. And, well, the question that would come is, how did we arrive at this 28th of May, 2016? Because what I'm not seeing in the addendum is, yes, we have the date, but the actual, I mean, there's no program of works or even a summary of program of works to indicate that all the factors were considered in arriving at this extended date, particularly when the ECOM correspondence indicated from day one that the contractor was virtually incapable or chose not to. I wouldn't like to think a contractor like OAS is not capable of providing a program of works, or probably they chose not to present any proper program of works. And it was always a bone of contention. The engineer was saying that they actually had to program the works during the course of the contract. So in light of all of that, arriving at a date of 28th of May, 2016, I'm just asking, I mean, based on what you have seen, how was that date determined?
Providing realistic programs, Mr. Chairman, seems to be the Achilles heel of all contractors in this country, including the foreign ones. So, OAS came here with all their experience and so, and based on what I see from ACOM, ACOM had to have, how you call it, workshops with them to get them to do a program and to do a schedule. And even so, they did not have let's say, a reliable, accurate schedule. Now, if you don't, all right, so they didn't have that. But somehow we are able to evaluate claims that they submit. They will submit claims for delays. And it could be onerous. It could be inclement weather. It could be not getting the site and things. So those things went in, and the ACOM would have sat on them, and some of them they evaluated, and they might have, you know, in a particular batch, they might say, okay, yes, they award you X months, days, hours, whatever it is. Let's say X months. So they will add that now to whatever it was before. So that happened before Addendum 2. So the date was now, because when they started, it was 4 years, and then, you know, changes came. So the date now was was May 28. So when Addendum 2, when it was time now to execute or whatever, Addendum 2, they were not changing that any further. They were saying, okay, we'll keep it there. But, you know, they gave them, after that date, 156 days before applying any liquidated damage. So in truth and in fact, you move it from there, from 28. Or what they did say is that during that time, they're not paying, how you call this thing? Overheads and well, no, they're not paying delay damages at all. They're not paying overheads at all. But, well, yeah, and profit. But they're giving you 156 days, which is an awfully long time, to me before I'll ever apply liquidated damage. So, so Addendum 2 just use that, and they're using the same time of 28 May 2016. But they probably did that because that suited OAS, because remember, they don't want to remain here, they want to get out. So they wouldn't do it, they wouldn't move that date at all. So it's May 28, 2016. So it was not changed in Addendum 2, it was just used and memorialized.
Yeah, Member Abraham.
Thanks, Chair. I mean, we're speaking about a few things, well, what would have led to delays and not delivering the project in on a specific time. Earlier on, you did bring up a point where at one point in time they were stating that there wasn't materials on site. Being a foreign contractor, I can only assume that the materials were locally sourced. Seeing the direct inputs and the rapidity and the regular supply of cash and payments to them, did you pick up at any point in time that they stopped providing payments to local suppliers to bring about a delay based upon the availability of raw materials?
Mr. Chairman, that came to us as a surprise. The extent of indebtedness to local contractors and other suppliers who were engaged in providing services for that job. Almost everybody was owed. That's one. Secondly, raw material, well, of course, aggregate and thing, they were able to import aggregate. So they imported aggregate for that job. And I say so subject to a correction from Dennis. Normally, we will pay for material when it is incorporated into the works. But I think we were given some payment. Right, all right, so I'm correct. I think we gave payment to the contractor and IPCs once the material is made available. From wherever you have the material here, you'll get, once it's placed in some place, it's insured and what have you, you'll be paid for it. And the purpose of that, or the reason for so doing, is to provide cash flow to OS. So everything was done to facilitate them. More than one will probably do it any local contractor.
Chair, if I may, I'm spinning out a little further away from this, but it relates to this. I mean, it begs me to wonder why we had to import certain items. Maybe you can explain why. But what about the quality control and the specifications of the types of material brought in and imported? How did that go with respect to maintaining the standard that we would have wanted for the project?
Mr. Chairman, well, before any material is imported, the material is subjected to testing and so, and one will ensure that the quality of material meets the specs. So that's one thing. Why did we import? I wear another hat for another place. And one of the problems we have here is that there is a shortage of quality material for doing these highways and so. There is a quarry at the other, overseas next to us, and they have good quality of aggregate. So normally, if you could get it from there, you are good. We have a local quarry here, and it has good aggregate, but in recent times, it has fallen on hard times. It is not as, well, I wouldn't even say not as profitable, but the volume of the production coming out of that quarry cannot satisfy the demand. But the government has made a very firm, taken a very firm stand that we are not going to be importing any rocks for any job. So we have to find a way to generate it locally.
Just before Member Sagram Singh Suklal come back in, just as an extension of what Member Ibrahim asked, there were, I think within your responses, you indicated that there were 138 non-conformance reports issued by AECOM to the contractor. So in connection with that, if roughly, what percentage related to unsuitable materials, or was the bulk of it related to workmanship and, poor workmanship, non-conformance with specifications, non-conformance with designs, and then in the whole context of the continuation of the contract, and continuing through addendum number 2, a contractor with 138 non-conformance reports, would that not have sent a signal regarding the intent of the contractor with regards to the overall project?
Mr. Chairman, to some of us it will. It will tell us that that contractor, and if he's as world-renowned as, as we say he is, he does not have his A game here. A lot of this thing had to do with workmanship. Concrete work and things like that was poor. I don't think, well, Dennis could help me here. Dennis, could you fill in here and tell me, tell us, what the non-conformance, in your thing, what they were about? Dennis was more hands-on.
Chairman, through you, I would not be able to give an exact percentage based on quality workmanship, but you are right in saying the non-conformance report straddles material, workmanship, concrete especially. There were some areas where there were issues with sub-base materials. Those would have been issued by AECOM, those non-conformance reports, and the contractor would have been required to remove and replace or identify a suitable corrective measure to bring those particular areas up to standard. Some of the areas of non-conformance fell within concrete structures, in particular between St. Mary's and Mondesir, there were some areas where there were concrete failures. Concrete quality, the contractor was required to remove and replace those structures, and he so did. But to give an exact percentage in terms of the different areas,
yeah, I mean, just on the spot, it's difficult to give an exact percentage, but would the extent of the non-conformance significantly contributed to the delays on the project?
Again, Chairman, through you, yes, you would find through some of the reports that AECOM would have communicated that the contractor, in some cases, were not properly executing the work, so perhaps having to do significant corrective work, and in fact, it contributed to delays. So that would be a correct assumption.
Okay, thank you. So, okay, Member Dinobre. And then we'll go to Member Sagram Singh Suklal, and we're looking to close off at 5.
Chair, thank you. Chairman, every time you come here, I think this is the 3rd time. I think that the next session will be easier. I have to tell you, I am constantly baffled by what we are seeing playing out in front of us. Chair, based on what you just asked, and Chairman, I am drawn to a letter from the then president of NIDCO to OAS, dated the 28th of April 2015. And in that letter, that is the letter that outlines to OAS that they are aware of the bankruptcy of OAS and their right to invoke Clause 15. However, in that letter, it appears to me as if the president who has signed, of the then president of NIDCO, who has signed the letter, has basically laid out the argument for the contractor as to why they would have been underperforming on the project. And nowhere in the actual letter does he refer to any of these non-compliance reports, any of the underperformances of the contractor during the time, and simply says that basically there's a lack of material, or a lack of I don't have it in front of me. I have to apologize, Chairman. You have it in front of you. I don't know if this question is for you or for the current president, but would you say that this was an irresponsible approach taken by the then president in laying out the argument for the contractor, who has numerous 130-something non-compliance reports, and laying out an argument as to why they would have underperformed, and as a result of that, as I read the letter, they are willing to forego the enforcement of Clause 15.
Mr. Chairman, let me just make a quick statement here before I give way to the president. Some time ago, I said about having enablers. And to me, when you look at how OAS was treated here, I have never, and for a long time of my career as an engineer, I had a contracting firm. And we were never given that type of come by here kind of a treatment, right? There was a contract. There were rules governing the contract. You had to know the rules, and you had to apply the rules. So when liquidated damage is hanging over my head, I took steps to up the production so that I will avoid that eventuality, right? Here we're saying, well, you will not be penalized until 56 days since. Here you have a situation where the difficulty is being highlighted, and the way out is being explained to you, what you could use to sort of wiggle your way out of the thing. And don't bother, I'm watching your back. And that's a kind of a feeling you got here. In fact, when I started this thing, I was always asking a question, who is looking after the employer's interest? And that was not the case at all. I even chaired a meeting with the same CFO and so on. They came and, they were just, problems. And they're coming to us. And they wanted us to just approve that term sheet to get it $65 million. I can remember telling them, well, I have heard what you have said. But I can't understand how you want me now to do that. Because when you got that job, you got it on the grounds that you had the wherewithal, financial, whatever, to do the work. So to now tell me that I must allow you the freedom to offload the job back to me. So all the risk now coming back to me. Price, time, everything coming back to me. And then you can go back to Brazil and just thaw there. I just couldn't accept that. President.
I think the chairman has been most eloquent. I certainly endorse everything he has said there. I've never written a letter similar to this, and I can't see as a president, I would write a similar letter.
Sorry, go ahead.
Given what you have outlined today, inclusive of your last two answers, you also spoke to us about an oversight committee that was in place, and you listed out the persons who made up the oversight committee, chaired by the then Prime Minister and being made up of, if not all, most of them being cabinet members and high-ranking cabinet members. You also said, Chairman, that you do have some minutes of the meetings of the Oversight Committee. In any of those minutes, is there any reflection of the performance of OAS on the project? Or poor performance of OAS on the project?
No, Mr. Chairman. The minutes that I have dealt almost exclusively with trying to make the right-of-way available to the contractor, i.e., to have the properties to be acquired, and but you had a combination of property owners and squatters. And when you're dealing with a project with such a large footprint, with squatters, with property owners, you can't even talk about going and do an evaluation and using compulsory acquisition. It doesn't work so. Because when I say it doesn't work so, you have the law. You remember I said all things are legal and all things profitable? If you were to attempt to put hundreds of people, 500, 600 people on, just throw them out, it's not going to, the optics wouldn't be right. So, and you will not be satisfying maybe your CEC and even the World Bank approach to that. So that committee focused a lot on finding alternative accommodation or places for those people, whether it is in Pitimoon and some other places where they were developing lots so that people could get lots there, building lots that they can move into and reestablish their homes or whatever. They had lots like that. They even had some like agricultural homestead because you had people doing farming within the right of way. So that committee, yes, they worked a lot in that area, but outside of that, I do not see much action from them on any other in any other area.
And Chairman, again through you, PS, I'm not sure if we've addressed it today, so if we have, I apologize. Is there any documentation that exists at the ministry where NIDCO is updating the then line minister, or from the ministry to cabinet, updating the cabinet as to the issues that are ongoing as outlined today? Further to that, PS, I know that there was an increase in and the chairman has explained the reasoning for the increase in the overall project price, even though work had been taken out of it. But I know that also still fell within the overall budget that had been agreed to by cabinet, approved by cabinet. Would there still have been a requirement to inform cabinet as to the fundamental changes that had happened, the rationale behind it, to allow for cabinet to at least give NIDCO at the time the go-ahead, officially the go-ahead to proceed with the plans that has been laid out before us?
Thank you, Member. So, at the ministry, yes, we do have cabinet minutes, notes and minutes informing cabinet of different aspects of the project as you go along. It tended to be in the main as it relates to land acquisition. The chairman sort of outlined, it became a very intricate process, so there is that. The second question I think you've asked is the need to inform cabinet. So even though, as was laid out by the chair, the overall cost may have stayed in a similar parameter, what is being laid out is that the scope did not. And at that, yes, you would necessarily want to advise of that. I'm not sure if it's a third question or if it was a question within the first question, but the information that we are getting at this gathering, there's no record of most, if any of that, at the ministry, far more for it being placed before cabinet.
So, based on what we are being told, we have major decisions being made, costing hundreds of millions of dollars, scope being changed, and there is no documentation that allows or empowers NIDCO at that time to make these decisions, having informed the line ministry, having informed cabinet. However, we do have an oversight committee made up of cabinet ministers, led by the Prime Minister, who is meeting weekly, if we are to understand what we've been told, who's meeting weekly with NIDCO. We have also been told today that we have seen letters from, we have seen a letter that that refers to, or a letter to the line ministry, but no letters coming back with regards, no correspondence coming back to NIDCO with regards to this project. Am I safe in saying then that there is nothing that comes, no documentation that comes from Ministry of Works to NIDCO with any instruction that allows any of this to have happened with the authority and blessing of the line ministry and cabinet?
I would say I'm not aware at this time. We would go back and we would make a concerted effort to look, but I'm not aware.
Yeah, please.
And just one last question. We did talk about the poor workmanship. That has been discussed. There is one question that I have, and if it is that in addendum number 2, any of the value engineering changes, is there anything in addendum number 2 that firstly, that impacted the infrastructural integrity of the project? And if any of the specifications outlined in the original contract were changed by addendum number 2.
Mr. Chairman, that is such a good leading question for me to say what I'm about to say now. This whole thing about value engineering has been misused. We had to build a highway with 4 lanes, not at grade crossing, but elevated crossings and what have you. Coming out of addendum 2, changes were made. So you remove, how you call it thing? Grade separators and so, bridges and so, and you put roundabouts. That is not value engineering. It will be value, all right, let me tell you what the value engineering is. In St. Mary's, for example, the finished elevation of that road was lowered. And by lowering it, your abutment walls and so become shorter, your embankment becomes lower, and as a result, a cost saving is realized. That is value engineering. And what's the difference? At the end of the day, the indicative design that you start off with, that I expect to get, I'm getting it, but I'm getting it at a better price and what have you. But if you now take out the separated thing, and you now say, well, okay, let me put a signalized crossing here, put some traffic lights. That is not value engineering. If I ask you to build a 10-story building for me and then you end up building a 6-story, of course it's going to be cheaper. I don't know value engineering. You have truncated my scope. So that's what we did. So in a number of cases, they removed elevated thing and you put roundabout. And they describe it as value engineering. There's no value engineering, right? You didn't have value engineering in how do you call it, in Addendum 1. You remember that road from Dumfries to Paria Suite? You couldn't find value engineering to do it, although you said the contractor going to find it. Come hell high water, he's going to find it. After saying so, you then peel out $17 million and you give it to him because he said it's $34 million. You peel out $17 million and you give it to him. You say, okay, we'll go on halves. You'll give him that. Where was the value engineering then? Right? So it's a lot of buzzwords just floating all over the place. Right? So it's value engineering and then you end up giving, you're telling me I have roundabout? That's not what I asked you to do. That's not what we set out to do. So I thank you for giving me that opening, but that is like a boots on my corner, and the fact that you use that word value engineering, right? It's a misnomer here.
Senator Sukla has some questions regarding the timeline and just to tighten up on it, but before I go to her, in terms of the benefits, or in inverted commas, that was supposed to accrue from the addendum to bring the project to conclusion, to completion. I think one of the points that have been put forward is that a negotiated agreement between NIDCO and OAS would have had the potential to waive all claims and disputes. And that would have been one of the incentives. I think what was also stated is use of local contractors would reduce the employer's risk. We dealt with that. And a transition from OAS upon the exit on May 2016 to local contractors, we touched on that a bit. But in terms of wanting to negotiate an addendum to bring the project to completion, that this would have been a decisive intervention in terms of foregoing or bringing to nil all claims and damages coming out of the project. In your opinion, do you think that would have been sufficient based on looking at the potential for claims and damages from the contractor, that would have been sizable enough to predicate such a decision to move forward with OAS?
Mr. Chairman, I will probably argue no. And I will say why. When Addendum 1 was being dealt with, it was said that the contractor will forego all claims that he has for a period. And those claims were tallied up to be $159 million. But there's another significant thing about those claims. They were not assessed. They were claims sent in by the contractor. And you put them all together and it says $159 million. So if you pay $17 million to prevent yourself from paying the other $17 that you had to do to pay the man to finish the road, plus $159, you're ahead of the game. You have done well. So later on, when I want to give NIDCO, when I want to give, something, when I want to give OS something, the new president or the new, what they call it, chairman, and so should not cavil at that, because look, we got something here. So the same thing applies to Addendum 2. My question will be, were those claims assessed? It's all when a good contractor makes a claim. Were they assessed? What was the value? But if you took all the contractor's claim for a period of time and you tally it up, you'll get a large, formidable looking figure. And as such, that might justify what you then gave away in Addendum 2. So I'm saying that on the surface, it has the potential to work in our favor, but I'm not too sure about that because I don't know what claims you know, what was the actual value of the claims that you used that to offset.
But did OS present after Addendum 1? Okay. Did they present any claims arising between Addendum 1 and this time of Addendum 2? And if so, although you're saying they were not assessed, do you have a figure of what additional claims came up that were submitted by OS after Addendum 1?
Mr. Chairman, we'll have to check the record and get that information back to you. Huh? All right. Well, yes, but I don't have it. So we'll group it. We'll go back to the record. Mm-hmm. Identify what claims were submitted between Addendum 1 and Addendum 2. So we'll put what the contractor submitted, what was assessed, if any at all, and give you those figures. So we'll submit that separately, if we might be so permitted to do.
Yeah, definitely, because I think the committee would like to assess the statement that, let's negotiate, keep OS on board, because we are going to be able to forego all these claims and damages. So, yes, the committee would be interested in seeing the quantum, and if any assessments were done, the value of the assessments. So, hand over to Member Sukram.
Chair, thank you, and I know we have gone through quite a lot today. As this saga unfolds, Chairman, it is clear that OAS, they give you a hit and run, and they were allowed to get away with it. They were allowed to get away with it, especially because, Chair, we would have had the non-enforcement. Chairman George, you would have indicated that 15.2 was not removed, 15.2E was not removed. It was not enforced. And I come back to the point about the hit and run that OAS was allowed to give the people and the taxpayers of Trinidad and Tobago. And it is more evident with the whether it was the removal, whether it was the non-enforcement of Clause 15E. And to date, it is clear that it will go down in the history of Trinidad and Tobago as one of the largest atrocities that would have ever the taxpaying citizens of this country would have ever had to undergo. That being said, Chairman, through you, of course, as a matter of just summary, for my mind and just for clarity in my mind, and you could just agree with me as I just briefly go through these dates. March 31st, 2015, we would have had OAS, of course, filing for a judicial reorganization. You would agree with me. Then you would agree with me by August 20th, 2015, there was a draft addendum that you would have referred to. Then you would agree with me that by September 4th, 2015, Addendum 2 was executed. You will have to agree with me that September 4th is a significant date because September 4th was one day before the September 5th, which was the general election of Trinidad and Tobago that year. You would agree with me on that point. And as I'm on that point, I just want to go back and again, for the benefit of just clarity in my mind, in 2010, this contract would have gone through several administrations. In 2010, OAS was adjudged, when OAS was adjudged as the preferred company after submissions for their proposals in 2010, a then administration made a decision that they will only continue with negotiating and works of OAS after the 24th of May 2010. And your submissions would have alluded to that. The 24th of May 2010, they deferred, the then administration deferred negotiations with OAS, recognizing that the 24th of May 2010 was an election date, was a date that election was set for. And yet,
Remember, I'm not sure where you're going with this.
no, Chair, it's just the comparison.
Because, when you mention about election dates, what are we looking to tie what is happening here with?
I'm just looking at the difference in operations, Chair, because we had, and it has nothing to do with the administration, it just has to do with the timeliness of things. And that is just the clarity that I want in my mind, because in 2010, we saw that OAS was recognized as the preferred contractor, but yet a decision was taken that we will not engage in negotiations because there was going to be change, there was going to be an election on the 24th of May 2010. The simple point I'm making, Chair, is that yet we have in 2015, we have an addendum which is executed, and I will reiterate the point of the hit and run to the taxpayers of Trinidad and Tobago that is executed, of course, on the day before a general election. But I will leave that point.
No, but remember when you say, like, when you make statements like hit and run and the atrocities and those things, that as a committee, that is not a finding of this committee.
Of course not, Chair.
Because we are still deliberating, and what you're expressing there is a view.
It's a personal opinion, Chair,
so
and I could
think we
say
need
that.
to be a little more careful about this type of
Guided by you,
statements,
Chair.
yeah.
I'm guided by you, Chair, and I would leave that there. But just as a matter of timeline again, so September 4th, we had the execution of that addendum. Once that addendum was executed, between September 4th, 2014 to the 31st of December 2015, would you just be able to write it? I know we are closing and we of course are rushed for time. The amount of work that was completed during that period of time, would you be able to just briefly give us just from September 4th, where the addendum was executed, to December 31st, 2015, for the purpose of the record, what was the scope of work completed during that period of time? And I'm asking the question because I'll ask the final wrap-up question. How much money was paid to OAS by the 31st of December 2015? So simply put, from September 4th, 2015, we had the addendum executed. From that period to the 31st of December 2015, briefly what work was completed, and by, of course, 31st of December 2015, what monies were paid on the record to OAS by that
Chairman,
date.
I have already indicated that I will furnish the committee with all the IPCs leading up, in that period, and that will give you an idea as to value of work done. So I should, through you, Mr. Chairman, crave the indulgence of the member to just bear with us. Just give us a little time. We'll go back and we'll furnish that information to the committee.
Of course, Chair, through you, one last thing, but would you be able to identify then? So yes, I accept, of course, through Chair, us getting that information, recognizing that you will take time, it's nitty-gritty, but money spent. Do you at least have an average? Would you be able to at all say by the 31st of December 2015, how much money then was paid to OAS?
I would really like the member, Mr. Chairman, to just bear with us. I mean, we have some information in the documents that we have submitted, and if that has to be upgraded, we will upgrade it and we will furnish you before the before the end of this week. Will that be good enough?
Yeah,
Thank you.
that is acceptable. And at the same time, Mr. George, maybe Mr. Harichan Kadam, in the appendix, there is an appendix that was submitted by you all, in which all the IPCs are there. in terms of the amount. But if in the exercise that you are doing, if you could add in a column as to when the payments were made, actually made, it would assist the committee as well in its deliberations. Yeah. If we can get a column, yeah, with when the payments were made, that would help. Yeah. Member Sukla?
Thank you very much, Chair. And if, I'm not sure if it is in writing or if of course, if Chairman George can answer that question now, it comes back again to, you made the point of enablers, Mr. George. Of course, when my colleagues would have identified some of the for want of a better word, the red flags that were already existing, non-execution of work, delays, poor workmanship, of course, so when Member Dinobrega asked you the issue of value engineering, all of those things were existing. And yet we have, because we are on Addendum 2, and of course, in that conversation, very early in this inquiry, we would have spoken about clause 15, 2E not being enforced. I'm not sure if you are in a position, after all of these red flags, after all that has happened, if there is any evidence on the record that can suggest why a decision was still taken after everything that has been said to not enforce, because you have said it was not removed, it was simply not enforced, why after all of this a decision was still taken not to enforce. Of course, not asking you to speculate, asking you to refer to evidence that you may have why 15(2)E was not enforced in an attempt to protect, of course, the taxpayers' dollars of the people of Trinidad and Tobago.
Well, Mr. Chairman, I'm happy that the member is not asking me to speculate, and I shall not do that. But I would say this. If this same thing were to come before the board that I chair, there is no way we're going to be so accommodating. We will question it. We will ask the president. There is no way that is passing us. So I'm just saying, we are ordinary men. The board might have had more august people on their board. And in fact, they even thought about it, when they asked, have you been telling the minister? And the answer was yes, every Friday, we tell the committee. So they got a level of comfort from the answer given. So that's what I will say, right?
So let's we wrap up at this point, and I would like just from you, Mr. George, and then Ms. Yearwood, any closing comments?
Mr. Chairman, members. Two things strike me here. Not so much for what went before, but lessons learned for us. We have to become more accurate with the laws that govern our contractors. We must know the laws and know how to apply them, and be prepared to apply them. Now, one might say, well, that's obvious. But those laws, so we have to go past just looking at the yellow book, look at case laws and see, well, how things were determined, how things were decided, and be guided by that in our application of the laws. Because if that NIDCO, that version of NIDCO, if they were sufficiently hard-nosed, there was no way that they would have passed up that opportunity to get rid of that contractor. Absolutely no way. So that's one. And I think we also need to develop skills in the development and use of schedules. A contractor cannot be at your throat. He wants extension for delays when there is no schedule to guide his operation. On what basis you tell me you're delayed? What if there are concurrent delays and things, you know? But what happens is that we allow those things to pass. The contractor sends in a claim and we sit on it because we don't like to go and adjudicate, assess and say, okay, yes, well, you're not due $10, but you're due $6. Nobody wants to do that. So we leave it alone. And time passes. Quite apart from our not observing the window that is given to us in the law, in the contract that we have, that we are administering, we lose valuable information, contemporaneous information that we can use to do the assessment. And at the end of the day, we have a whole pile of claims. Very, you know, sometime, you know, as in OS's case. I mean, how could you have listed claims to me valuing $159 million US. That's a lot of claim. Why weren't they assessed? You know, so I think, if nothing else, and finally, it makes no sense just doing risk assessment and not using it. We cannot, we must not, we should not start any of these jobs without access to the site, to deliver access to the contractor. Forget the feel-good projection we'll have. Or go and start, and by next month we'll have the rest done, we'll have the site available to you. That is not happening. So we need to give ourselves some lead time to engage the project. Now, it is not very attractive because nobody sees that. No boots on the ground. But we have to give ourselves the time to engage the project before boots get on the ground, to ensure that a site can be delivered to the contractor free and unfettered so that he can get on with the work. And to the extent that we do that, we will be delivering value for money to our employer and by extension the people of the country.
Thank you, Mr. George. Ms. Yehud.
Thank you, Chairman and members. I sat and I was trying to get my thoughts together, but I was taking in the what I think was an excellent overview of some of the lessons learned or to be learned from this particular project, because based on the information that we've had here today and in the past sitting that I've been to, if you look at it from an outside perspective, this project would have started on solid principles. We went out, we did a pre-feasibility, we went out, there may have been some learning curves in terms of the type of methodology to be used, and I heard the chairman on the last occasion speaking to the design build methodology, etc. And you know, there is a saying about hindsight and foresight. There seems to have been so much that would have happened from the what was a relatively decent start to the end, that one of the things that I am hoping comes out of this whole exercise really is a lessons learned document that can be used by the industry. I would say as well that we have been speaking to different incarnations of the entity that would have been implementing, and I can say that a lot of those, or the lessons learned identified, are now being implemented and exercised as we seek to undertake further projects. I have to say that because I wouldn't want the general public to be so alarmed to think that we are continuing in some of these areas in that fashion. So Chairman and members, once again, I want to thank you for having us here today.
Thank you. Let me thank both the entire team here, representatives from NIDCO and the Ministry of Works, and to thank Mr. George and Ms. Yearwood. You know, those closing remarks, although brief, you know, I think the context in which it has been said, and the fact that going down the road in terms of looking at the past, learning from it, but also trying to ensure that, you know, we improve as we go along. We always have to seek to better way to do things, more efficient way to do things. And thank you for sharing those thoughts with us as we close off. It's a good note to close off on. I'd like to thank the viewing and listening audience who have tuned into our respective channels. I'd like to thank all committee members and the staff of the Parliament, to thank the Secretariat headed by Mr. Johnson Greenwich. This is indeed, I keep saying it, and I will keep saying it, it is a tremendous workload for our Secretariat, especially this particular inquiry, due to its extent and scope, and the fact that the project started so long ago. And we are now looking at some things regarding it. So it's a lot of work, and our appreciation to our staff. So I'd like to suspend the meeting. Thank everybody once again, but invite members to please stay on for our post-hearing discussion. Thank you very much.